I mean, good morning and welcome to Defense Diaries. I am your host, Bob Mata, and this is our continuing coverage of Delphi Unhinged, People of the State of Indiana versus Richard Allen. And I am joined by my beautiful and brilliant co-host, Allie. What's up, girl?
I don't know what just happened. Oh, there I go.
Hey.
Can you hear me?
Yeah. We missed the hey babe though, which is your signature. So what's up,
Said
girl?
that first. Hey babe, hey all.
Yay. All right. All right. So as you may or may not know, tomorrow is the day that Richard Allen will be sentenced. Tomorrow down in Carroll County, Indiana. It will take place at 9 a.m. I just saw that there was a press release that McClelland, Holman, Carter, and the families are going to be doing a press conference right after sentencing. I think across the street at a spot. So, but today
we need
what
a
came
big
out,
camera so you can,
you mean other than my phone?
Yeah.
But today the defense filed its sentencing memorandum, which we were going to go through with you guys today. It's interesting. I'm not surprised by it, by the tone and tenor at all.
I haven't read it yet, but I wonder if some of it's like for the public, like, okay, don't get your panties in a bunch. This is normal operating procedure.
Right. Well, I think what we're gonna look, this is not going to be a surprise what's going to happen tomorrow. I mean, she is going to sentence Richard Allen to the maximum allowable under the law. But I want to clarify some things. I think that he was convicted of 4 counts. He can't be charged for 4 counts. We'll go through it when we're there. But all right, you want to pull up this? I'm going to pull it up. You ready?
Yeah.
All right, let's go. Okay.
You got me for the next 42 minutes.
We should be good.
Oh, no.
All right. So this was filed after hours yesterday, 4:53 p.m. on 2/18. The judge had essentially ordered the defense to file its memo, and I believe that she gave them until yesterday, close of business. So they got it done, and it's definitely snarky. It's definitely snarky, and
who drafted it, sir?
If I had to guess, I would guess Andy. I don't know. We'll leave it for a surprise at the bottom, but it reads like Andy. It reads like Andy.
All right, it's going to be the big reveal.
The big reveal. Okay, sentencing memorandum comes now. Defendant Richard Allen by and through counsel Andrew Baldwin, Brad Rosie, Jennifer Auger. I think the fact that Andy put his name first would also be a good indicator. And in anticipation of the sentencing hearing on December 20th, 2024, in the above referenced cause number, respectfully request this court to fashion an appropriate sentence in recognition of the foregoing memorandum. Practical sentencing issues and constraints. Richard Allen maintains his innocence and is hopeful that the appellate process will provide him with an opportunity to present a full defense at a second trial. For this reason, Richard's defense counsel advised Richard Allen to not participate in providing information for the pre-sentence investigation, PSI, report to the Allen County Probation Department, as defense counsel assessed that there was no value in Richard Allen continuing to talk with state actors. Now, what do you think of that?
I'd say it's absolutely true. I mean, there's no value for him to participate at all. I mean, I think they wanted to add to even talk to state actors because it's implying there's been a lot of corruption with all these state actors, so we're not talking to them.
Right. I agree. I think that ultimately there was nothing to be gained by it. Like, this isn't a situation where they're going to present a bunch of mitigating factors and they're, going to be on bended knee, asking the judge for leniency. And we knew Allen wasn't going to be,
Accepting responsibility.
accepting responsibility at all. So there was really, to me, no advantage to having him work with PSI, because I mean, probation, when they're coming in, I mean, they're really, they do ask a lot of questions, like,
Yeah, they're
explain
gonna say if
briefly
they
kind of what
showed
they get into.
well, I mean, part of what they get into is whether the person's showing any,
Remorse.
remorse, for what they've done, but they do ask them about, what led up to it and, all sorts of questions about their medical background, their family background, and the offense itself and the events leading up to and after the offense itself. So there is really no benefit to Richard Allen participating. I think they chose to use the words continuing to talk with state actors for the reasons that I said, because they could have worded it differently and just indicate that we've assessed there would be no value to Richard Allen. Period. So let's see what that handy dandy footnote says. If you're muted, Bay. I thought you were
Sorry,
really
I hit my cough button.
oh,
All right, so it should be noted, this is footnote 1, for the record, that this court hand-selected the Allen County Probation Department to conduct the PSI and interact with Richard Allen without any input from the defense, nor any explanation as to why Carroll County Probation Department could not conduct the PSI. Additionally, Carroll County Local Rules LR 08 TR 79-10 provides an analogous example of how a special judge should be selected from a contiguous county, and believe that the proper methodology for selecting a special probation department appointment, should a good reason exist, would be appointing a probation office from a contiguous county to conduct the PSI. So they've got a good point. I don't know why
me
she's
neither.
appointing. I mean, he wasn't even held in Allen County, but for, I think, the few appearances they did over there, like during the day, during while the hearing was going on. It's inexplicable to me why she was assigning her own people. I don't know. I mean, it doesn't surprise me, obviously.
Yeah, she can do what she wants
Yeah, she can
whenever
do
she
what she
wants
wants.
without
So,
any repercussions.
well, I mean,
That's what I've seen so far. That's what I've
that's
seen so far.
right. That's the broad argument. The narrow argument is that the repercussion is she's about to continues to ensure that Richard Allen's going to get a second trial. That's the counter argument, at least.
I would hope so. We'll see. So far, there's been no repercussions.
Yeah, well, I mean, during the course of the litigation, yeah, there was
I
nothing.
just feel like there should have been a little bit of a heavier um, tone, maybe, with the Supreme Court to make her fall in line. But
Yeah, I mean, Olivia. Uh, I mean, how long do you have? We have an awful lot of content on Delphi. You could dig in at any point.
Well, she's saying that in jest. What, if anything, is explicable in this case?
I misread it as inexplicable. So yes, that's right. Yeah, it's another one. It's another one. All right.
Now Darren's got to cut that whole little diatribe out.
All right. So throughout this case, I'm blind, right?
Yes.
So throughout this case, Richard Allen has brought to the court's attention that he was detained in solitary confinement without due process. This constitutional violation by the state was then exacerbated by the assignment of the staff psychologist contracted by the IDOC, who, while having a deep personal interest in this case, engaged in, quote, confidential, end quote, discussions with Mr. Allen about the details of the acts for which he was accused. In total, Mr. Allen was housed in 4 different jails or prisons during his detention without any input from himself or his appointed counsel. During this time, Mr. Allen was exposed to staff, law enforcement officials, and offenders, all of whom have reported circumstances which negatively impacted his defense. This is not the intended purpose of pretrial detention in our system of criminal justice. As a result of these constitutional violations, Richard Allen's defense team believes it has an obligation to protect him from the prospect of any further inappropriate contacts with state actors. Additionally, Richard Allen is 52 years old. Pursuant to IC 35-50-2-3, Richard is facing 45 years to 130 years of imprisonment. In the unlikely scenario that under IC 3552-2.2, this court would sentence Richard Allen to the mandatory minimum sentence and run the counts concurrently, on his best day, Richard Allen would receive a 45-year mandatory prison sentence. With good time credit, this would amount to 33.75 actual years in prison. This means that Richard, on his best day at sentencing, would be released from prison at 85 years of age. The practical reality is that unless this matter is reversed and retried, Richard Allen is likely facing the rest of his life in prison. Even on his best day at sentencing, Richard Allen will be 85 years old upon his release. With these facts in mind, the defense advised Richard Allen not to participate in the pre-sentence process. Again, his continued interaction with state actors does not make sense, considering that a second trial may occur, which would allow him to present a full defense. Additionally, Richard will be serving this lengthy sentence, whether he provides a statement to the Allen County Probation or chooses to avoid providing a statement to the Allen County Probation Department. This reality also precipitated the defense to advise Richard to not participate in the process. The defense provides this condensed sentencing memorandum considering the practical issues detailed in the previous paragraphs. So dismissals of counts 1 and 2. As you will recall, originally Richard Allen was charged with felony murder, which we've explained to you guys on multiple occasions, but the bottom line is that in that circumstance, the state would have merely have had to proven the kidnapping had occurred and that the girls had been unalived as a result of that kidnapping, and that would have satisfied that statute. Ultimately, the day that Rosie and Baldwin were reinstated, McClellan had added 2 additional counts, which were the 2 straight-up murder charges of Abby and Libby. So double jeopardy prevents Mr. Allen from being sentenced on both his murder conviction and the felony murder conviction for Abigail Williams and Liberty German.
So I'll just chime in here real quick. So yeah, you can be charged with multiple offenses in different ways, like felony murder, second-degree murder, first-degree murder. But when it comes to sentencing, technically the conviction that you're being sentenced on is only the highest. So that's what they're going through here. So even if someone were to be charged with first and second degree murder and manslaughter, for example, and being found guilty on all, technically their conviction for sentencing is the first degree murder, which encompasses every other lesser degree.
Okay, so Richard Allen was found guilty of count 1, felony M, victim 1, count 2, felony M, victim 2, count 3, felony M, victim 1, and count 4, M, victim 2. And then, however, the jury convicted Mr. Allen of both of the M's, the unalivings and felony M's, of victim 1 and 2, and victim 1 and victim 2. An individual cannot be convicted and sentenced for both
Red rum.
red rum and felony red rum. Yeah, that's way better than M. Where only one killing took place.
Meaning one killing per each victim.
Right. That's Hulfaker v. State, 735 Northeast 2nd, 214, citing Fuller v. State, 639 Northeast 2nd, 344. When a jury finds a defendant guilty of both red rum and felony red rum of the same victim, the court must vacate the felony red rum conviction and enter judgment solely on the red rum conviction. Therefore, Mr. Allen requests the court vacate his convictions for felony red rum and enter judgment solely on counts 3 and 4. So these are the statutory mitigating factors. Now, explain a little bit. In your typical sentencing hearing, there's going to be aggravating factors, which the state will bring forth, and there will be mitigating factors, which the defense will bring forth in order to try to sway the judge in terms of sentencing, and they will argue which factors apply and which don't, right?
And technically, the defense will also argue against aggravating factors and say, in this case, this court should not apply aggravating factor X, Y, and Z. And I'm sure here you're going to see the majority of the mitigating factors that deal with people who don't have any prior history. There's other mitigating factors that don't apply and won't be referenced here. Such as no harm came to anybody, or something of that nature. But yes, that's and you can make an non-statutory argument. It's depends on the facts of the case. I doubt they make one here. So let's go, babe.
All right. So first mitigating factor is 1 Indiana Code Section 3538-1-7.1 B6. The person has no history of delinquency or criminal activity, or the person has led a law-abiding life for a substantial period before the commission of the crime. Richard Allen has no prior criminal history, and he maintains his innocence on this charge. Richard's lack of any prior criminal history is a mitigating factor. 2, Indiana Code 35-38-1-7.1 B10. Imprisonment of the person will result in undue hardship to the person or the dependents of the person. So Richard Allen was the main breadwinner for the household before he was arrested and sent to Westville Prison without a hearing or attorneys present. His imprisonment has created and will continue to create a hardship on his wife of 30 plus years, Kathy Allen. So non-statutory mitigating factors, a number of non-statutory factors exist in this case. Among them, Richard Allen served in the United States Army National Guard for approximately 10 years, having enlisted when he was in high school. And Richard Allen has a long history of mental illness, having been treated for major depressive disorder and anxiety disorder throughout his life. His mental health condition was corroborated by the records of the IDOC created during this intake process at the Reception Diagnostic Center, and again, through the records created by his assigned mental health providers at the prison, as well as the independent neurological exam results generated by Dr. Polly Westcott. These records were introduced as evidence at various phases during the trial, and therefore, the defense requests that this court take judicial notice of the same. The defense would further request that the court acknowledge the legitimacy of his mental health condition in the guilty plea and sentencing order, so the IDOC is on formal notice of his condition when a determination is made as to how and where to confine Mr. Allen while his appeal pens. Conclusion. Richard Allen maintains his innocence and looks forward to the appellate process, which he anticipates will include adjudication by a neutral, detached, and unbiased tribunal. Richard Allen believes that he will be afforded due process under the law and he will be permitted to present a full and complete defense at a future trial in this cause. For that reason, as well as the other reasons identified herein, Richard Allen, 1, chose not to participate in the pre-sentence process. 2, will not be presenting evidence at the sentencing hearing outside of this memorandum. And 3, his attorneys will be speaking and articulating arguments in minimal fashion during this sentencing hearing. Respectfully submitted, Andrew Baldwin. So there you go. There you go. All right.
So somebody asked about if the jurors were gagged. I don't believe the jurors are gagged. Right? She can't gag the jurors until after sentencing, can she? Did she? Robert?
Hold on.
Oh.
I'm texting. It's related to this live text. I'm not sleeping and I'm not ignoring anybody. So just talk for a second. I'm actually
Okay. They executed a man yesterday in Indiana. Gull sent to death row for 1999 for quadruple red rum, first in Indiana in years. Wow.
All right. Well, I wait for an answer on that.
Thanks, Melanie, for your generosity. Corrupt judge, corrupt prosecutor, corrupt sheriff, corrupt state equals don't participate in the pretrial. So Denise asked why you thought the jurors haven't spoken out, and there was a response that somebody thought the judge gagged them until after sentencing.
There was no order
Right.
gagging them that I'm aware of.
I don't think that a judge can gag the jurors once the verdict has been handed down. I would assume that it is
Judges are popping off these days. Like they're gagging family members and like people that they have no
maybe she
business
did.
gagging. I don't know.
Maybe she did instruct them not to speak. But I think I would, if she hasn't instructed them not to speak until after sentencing, I think that they made a decision and they're probably sticking to it. I don't know. Maybe they will speak after sentencing.
Yeah. Okay. So I'm gonna pull up and I see that there was a little confusion in the chat about the sentencing over there. Cara Wieneke, our friend, had put a pretty detailed tweet out there, or X, whatever you want to call it these days. It's instructive. I'll put it up. She is a appellate attorney extraordinaire in Indiana. I find her to be one of our very best resources in terms of getting accurate information about the process in Indiana. So
for sure,
let's read what Cara had to say. So it was in reference to this article that was dropped by some newspaper. Oh, the Comet. the Carroll County Comet put out a little article. So
shouldn't we read the damn article so that we? Well, I guess she goes into it. So
she goes into it. So and she clarifies what they got wrong. Sentencing, if you're late to the party for Richard Allen, is tomorrow morning, 9 a.m. in Carroll County. Okay, so Cara says this is why it sometimes helps to consult with an attorney about possible sentences. The article contains 2 errors. First, the article claims that Allen could receive 4 sentences. Wrong. There were 4 counts, but only 2 victims. Only 2 red rums occurred. He can only be sentenced on 2 counts, not 4. Trial court will not enter convictions for the 2 felony red rum counts, instead merging them into the knowing red rum counts. We don't use that term anymore, but it's the easiest way to explain it. Yeah. Allen will only be sentenced on the 2 knowing red rum counts. Second, the article claims that Allen could receive a life sentence without the possibility of parole. Wrong. The time for the state to request life without parole has passed. See, this is why we bring up Cara's tweets.
Yep.
So under Indiana Code Section 35-50-2-9, the state was required to, before trial, file a request for life without the possibility of parole to be considered. Moreover, life without the a life without the possibility of parole is a determination made by the jury after the first phase of the trial, i.e. the guilt phase of the trial.
Very different to Illinois or other states that I'm aware of.
And life without the possibility of parole requires a jury finding one or more additional aggravating circumstances. The prosecutor did not ask for life without the possibility of parole in this case. It easily could have been a life without possibility of parole case or a capital case for that matter, but there was no reason for it to be. Given Allen's age, any sentence, even the minimum, is a life sentence. So what is Allen facing on Friday? Well, the judge cannot sentence him to less than 45 years, but she cannot sentence him to more than 130 years. So there you go. That is your definitive answer.
I suspect she goes to somewhere like 60 just because there's no point in going higher. He'd be 100 and something, but maybe she goes 130. I don't
think
know.
she goes 130.
Maybe she goes 100 just to be a little bit below and be like, I considered all the mitigating factors.
Okay. All right. We'll place a bet on it and you know what the bet is. It's always our same bet.
I'll go under 130. Is that what I get to go?
Yeah, I'm going. She's going to give him the max.
All right, I'm going 129 or less.
Okay, fair. Fair. All right, so now my plan has been to attend this hearing, and it has come to my attention that none of Richard Allen's family is going to be attending.
They're boycotting. Is
They
that
are
what's happening?
they are boycotting the sentencing hearing. And she texted me kind of a statement, but I'm asking for her. It's generic, but I'm asking if I can read it because I really want to. So I'm gonna have to think about it. I'm not gonna go to the sentencing either in solidarity.
You're deciding right there, right now?
Yeah, I might go down there just to listen to that press conference though.
We could listen to that sitting here in front of everybody.
Yeah, that's true. You think they'll? Yeah, I guess since it's not going to be in the courthouse, they'll televise it.
Yes.
Yes.
It will be televised.
Yes. So
hey, I love that idea. I get my man longer. We've got some Christmas shopping we haven't done.
Wow, that sounds fun. All right. Wait, there's a text bubble.
There's a bubble. I don't see why. I mean, she's perfectly within her rights to say whatever she wants.
Within her rights. I'm just texting her.
Just in case you're going to say no, Allie and I say you're perfectly within your rights. Although I honestly don't know what the gag order said, but that should be done.
That's a general proposition, right?
Yeah, she's not talking about the case.
Right.
Not facts.
It's not talking about the facts of the case. All right, well, we're waiting. So yeah, if Kathy's not going, I'm not going. That's all there is to it. So yeah, she's really thinking about it. It's like bubbles disappear. She's like, oh, what should I say?
Maybe she's amending it.
Maybe. Either way, whether
we'll either be here tomorrow with me, or with Bob from outside of the courtroom, or with both of us sitting right here.
Yeah. I'm gonna have to. You're right though. I forgot that it's not going to be. I think that's why they did it not in the courthouse, so that Gull has no jurisdiction over saying that they can't have some kind of. And plus, the real question is going to be, so explain the process real quickly as we kind of wrap this thing up. What to expect in terms of filing. Now in Indiana, they don't have the same process that we
right.
Here.
I spoke to Cara about it. So there's not, I can't give a good, we need to get Cara on here because they don't have the same requirements that we have. They don't have to file certain things to preserve their appellate rights. In Illinois, we would have already had to file our first round of post-trial motions before sentencing, and then if you're going to challenge the sentence in any way, shape, or form, you've got to file another one asking the court to reconsider the sentence. And I think there's something that'll get filed, is my understanding.
I think, well, yeah, it's what's called a motion to correct errors is what they file down there or over there. So it's got basically the same impact as a motion for a new trial. So they're basically arguing the same things. It sounds like they can get into some things that we typically cannot get into in our motions for a new trial that we file here. So it'll be interesting, but I believe that they'll have 30 days after tomorrow in order to get that on file.
I think what we should do is talk to Cara about coming on maybe tonight for, oh, I don't want to give us more work though, really. But I was going to say for an evening live. And she can answer questions about it, and we can, I don't know.
Yeah, I did. I saw Helen asked a question. I thought his attorneys waived his appearance. They would have had to file written notice of asking for Alan to not be allowed to be at sentencing. I did not see that. I know that there was some talk about that happening. As far as I know, I think they're
And a waiver probably would have been, even if they did it orally, his written waiver would have to be of record.
yeah, exactly.
Like he needs a written waiver to not appear in court on his own matter for something like that. A critical stage.
Yeah.
Kathy's still giving you dots. What's going on?
Yeah, she's really if she's that concerned about it, I'm good with not
doing it.
Not doing it.
Right.
So.
And we're going to come back tonight. So if she changes her mind, then we'll have our big live and we'll say something about her.
Well, you're being very presumptuous about Cara Wieneke's time. So let's see.
That's true.
Or
sorry, Cara.
Or Osbrook. Osbrook would also
Osbrook is much more controversial than Cara.
Yeah, I'm here for it though. You know, I mean, look, you know what Osbrook does?
He tells it like it is,
and he wins. That's what Osbrook does. He does habeas corpus.
Yeah, his legal acumen cannot be questioned.
Yeah, no, that Osbrook wins. That's what Osbrook does. I don't give a shit if he's controversial or not. And look, when you're fighting the power of the state, sometimes you have to be controversial.
Hey, we know that more than anybody. I mean,
do.
I've sat there shocked certain days you didn't get held in contempt of court, and I'm sure vice versa.
Me. Yeah, I was a mouthy son of a bitch in court sometimes, but it was always warranted. I felt that I wasn't just popping off for no reason whatsoever.
No,
it was always
you were always very professional.
It was like, except for that one time when I was yelling over the phone at
you know, sometimes you're not standing in the courtroom, you feel like you got a little bit, you can get a little bit more loose with your decorum, but not that you should, but I'm just saying.
And frankly, that was I was defending you.
I know.
Right. It was like I was so I probably was hangry.
There's a high, I'm sure.
There's a high likelihood that I was hangry.
There's very little eating going on around trial time.
The sea was hangry that day, my friends.
All right, yeah. I'm leaving you guys. And maybe I'll see you tonight, and maybe I won't.
All right, I love you.
Bye. Love you too.
Bye. All right, yeah, Cara definitely has some dubs too. As you all know, I adore Cara very, very much. So I think that pretty much wraps this. If we can get Cara on tonight, we will definitely do another live to kind of dig into some more of this. And I think I'm going to do another live probably this afternoon there's been some movement on the Luigi Mangione. There's some movement on his case. So he waived extradition today. They're going to be transporting him to New York forthwith. I believe that at some point tomorrow, he will be arraigned as the grand jury has indicted him, I believe, on 11 counts. So I think that that warrants some type of live. I don't know how long it will be, but there's kind of this interesting concept floating out there that the feds are going to throw their hat in the ring and they're going to charge him with some federal crimes. That'll be interesting to see. Allie and I were trying to figure out what exactly they might be charging him with. It seems that the most obvious charges would be related to the weapons or the weapon, but there would be some type of weapon charges. I haven't seen anything out there out on the streets in terms of what they might charge him with. Yeah, we've been checking too, DB. But there are rumblings that they will look. I mean, there's one thing that is going to be certain about this is that they are trying to do everything in their power to very much make an example of Luigi Mangione. So if the feds can toss their hat in the ring, they're going to do it. I was a little bit surprised that at least at this juncture that they did not Pennsylvania did not outright dismiss the charges pending there. They were obviously, in the eyes of New York, kind enough to turn him over because obviously the more serious charges are pending there. So all right, you guys keep your eyes and ears open. We will most likely, hopefully, do a live this evening, another Delphi live. Hopefully, we can get Cara on in anticipation of what's going on tomorrow. And additionally, keep your eyes and ears open for a Mangione live because I feel like there's probably a little bit to talk about with that. There might even be a presser at some point today once they get him into New York. So I'll be keeping an eye out for that as well. But you guys rock as always. We had a great crew in here. We got some love from the cool lady as usual. Thank you very much, Melanie Parker. Thank you very much. I know Allie already thanked you. Who's your girl always coming in hot? We love you 2 times there. So we appreciate that. And please, on the way out, if you'd just be kind enough to like and then share and subscribe, really helps us grow the channel. And we appreciate that very, very much. Because without you guys, I am just some old man talking about a whole lot of cases. Talk to you.